Jurisprudence is the social science, study and theory of law. It includes principles behind law that make the law. Scholars of jurisprudence, also known as jurists or legal theorists, hope to obtain a deeper understanding of the nature of law, of legal reasoning, legal systems and of legal institutions. Modern jurisprudence began in the 18th century and was focused on the first principles of the natural law, civil law, and the law of nations. General jurisprudence can be divided into categories both by the type of question scholars seek to answer and by the theories of jurisprudence, or schools of thought, regarding how those questions are best answered. Contemporary philosophy of law, which deals with general jurisprudence, addresses problems in two rough groups: problems internal to law and legal systems as such. Problems of law as a particular social institution as it relates to the larger political and social situation in which it exists. Answers to these questions come from four primary schools of thought in general jurisprudence. Natural law is the idea that there are rational objective limits to the power of legislative rulers. The foundations of law are accessible through reason, and it is from these laws of nature that human-created laws gain whatever force they have. Legal positivism, by contrast to natural law, holds that there is no necessary connection between law and morality and that the force of law comes from some basic social facts. Legal positivists differ on what those facts are. Legal realism is a third theory of jurisprudence which argues that the real-world practice of law is what determines what law is. The law has the force that it does because of what legislators, barristers and judges do with it. Similar approaches have been developed in many different ways in sociology of law. Critical legal studies are a younger theory of jurisprudence that has developed since the 1970s. It is primarily a negative thesis that holds that the law is largely contradictory, and can be best analyzed as an expression of the policy goals of the dominant social group. Also of note is the work of the contemporary philosopher of law Ronald Dworkin, who has advocated a constructivist theory of jurisprudence that can be characterized as a middle path between natural law theories and positivist theories of general jurisprudence. A further relatively new field is known as therapeutic jurisprudence, concerned with the impact of legal processes on well-being and mental health. The English word is based on the Latin maxim jurisprudentia. Juris is the genitive form of ju, meaning law, and prudentia means prudence. The word is first attested in English in 1628, at a time when the word prudence had the now obsolete meaning of knowledge of or skill in a matter. The word may have came via the French jurisprudence, which is attested earlier. History of jurisprudence. Ancient Indian jurisprudence is available in various Dharmasastra texts starting from the Dharma Sutra of Bodhayana. Jurisprudence already had this meaning in ancient Rome, even if at its origins the discipline was in the jus of mos maiorum, a body of oral laws and customs verbally transmitted by father to son. Praetors established a workable body of laws by judging whether or not singular cases were capable of being prosecuted either by the edicta, the annual pronunciation of prosecutable offense, or in extraordinary situations, additions made to the edicta. A iudex then would judge a remedy according to the facts of the case. Their sentences were supposed to be simple interpretations of the traditional customs, but effectively it was an activity that, apart from formally reconsidering for each case what precisely was traditionally in the legal habits, soon turned also to a more equitable interpretation, coherently adapting the law to the newer social instances. The law was then implemented with new evolutive institutionis while remaining in the traditional scheme. Praetors were replaced in 3rd century BC by a laical body of prudentus. Admission to this body was conditional upon proof of competence or experience. Under the Roman Empire, schools of law were created, and the activity constantly became more academic. In the age from the early Roman Empire to the 3rd century, A relevant literature was produced by some notable groups including the Proculaeans and Sabinians. The scientific depth of the studies was unprecedented in ancient times. After the 3rd century, jurisprudence became a more bureaucratic activity, with few notable authors. It was during the Eastern Roman Empire that legal studies were once again undertaken in depth, and it is from this cultural movement that Justinian's Corpus Juris Civilis was born. Natural law. Natural law theory asserts that there are laws that are immanent in nature, to which enacted laws should correspond as closely as possible. This view is frequently summarized by the maxim an unjust law is not a true law, lex iniesta non est lex, in which unjust is defined as contrary to natural law. Natural law is closely associated with morality and, in historically influential versions, with the intentions of God. To oversimplify its concepts somewhat, natural law theory attempts to identify a moral compass to guide the lawmaking power of the state and to promote the good. Notions of an objective moral order, external to human legal systems, underlie natural law. What is right or wrong can vary according to the interests one is focused upon. Natural law is sometimes identified with the maxim that an unjust law is no law at all, but as John Finnis, the most important of modern natural barristers, have argued, this maxim is a poor guide to the classical Thomist position. Strongly related to theories of natural law are classical theories of justice, beginning in the West with Plato's Republic. Aristotle is often said to be the father of natural law. Like his philosophical forefathers Socrates and Plato, Aristotle posited the existence of natural justice or natural right. His association with natural law is largely due to the way in which he was interpreted by Thomas Aquinas. This was based on Aquinas' conflation of natural law and natural right, the latter of which Aristotle posits in Book V of the Nicomachean Ethics. Aquinas' influence was such as to affect a number of early translations of these passages, though more recent translations render them more literally. Aristotle's theory of justice is bound up in his idea of the golden mean. Indeed, his treatment of what he calls political justice derives from his discussion of the just as a moral virtue derived as the mean between opposing vices. Just like every other virtue he describes, his longest discussion of his theory of justice occurs in Nicomachean Ethics and begins by asking what sort of mean a just act is. He argues that the term justice actually refers to two different but related ideas: general justice and particular justice. When a person's actions are completely virtuous in all matters in relation to others, Aristotle calls her just in the sense of general justice. As such, this idea of justice is more or less coextensive with virtue. Particular or partial justice, by contrast, is the part of general justice, or the individual virtue that is concerned with treating others equitably. Aristotle moves from this unqualified discussion of justice to a qualified view of political justice, by which he means something close to the subject of modern jurisprudence. Of political justice, Aristotle argues that it is partly derived from nature and partly a matter of convention. This can be taken as a statement that is similar to the views of modern natural law theorists. But it must also be remembered that Aristotle is describing a view of morality, not a system of law, and therefore his remarks as to nature are about the grounding of the morality enacted as law, not the laws themselves. The passage here is silent as to that question. The best evidence of Aristotle's having thought there was a natural law comes from the Rhetoric, where Aristotle notes that, aside from the particular laws that each people has set up for itself, there is a common law that is according to nature. The context of this remark, however, suggests only that Aristotle thought that it could be rhetorically advantageous to appeal to such a law, especially when the particular law of one's own city was adverse to the case being made, not that there actually was such a law. Aristotle, moreover, considered two of the three candidates for a universally valid natural law suggested in this passage to be wrong. Aristotle's theoretical paternity of the natural law tradition is consequently disputed. Thomas Aquinas, St. Thomas Aquinas, Thomas of Aquin, or Aquino, was a philosopher and theologian in the scholastic tradition, known as Doctor Angelicus, Doctor Universalis. He is the foremost classical proponent of natural theology, and the father of the Thomistic school of philosophy. For a long time the primary philosophical approach of the Roman Catholic Church. The work for which he is best known is the Summa Theologica, one of the 35 doctors of the Church. He is considered by many Catholics to be the Church's greatest theologian. Consequently, many institutions of learning have been named after him. Aquinas distinguished 4 kinds of law: eternal, natural, human and divine. Eternal law refers to divine reason, known only to God. It is God's plan for the universe. Man needs this, for without it he would totally lack direction. Natural law is the participation in the eternal law by rational human creatures, and is discovered by reason. Divine law is revealed in the scriptures and is God's positive law for mankind. Human law is supported by reason and enacted for the common good. Natural law, of course, is based on first principles. This is the first precept of the law, that good is to be done and promoted, and evil is to be avoided. All other precepts of the natural law are based on this. The desires to live and to procreate are counted by Aquinas among those basic human values on which all other human values are based. School of Salamanca. Francisco de Vitoria was perhaps the first to develop a theory of ius gentium, and thus is an important figure in the transition to modernity. He extrapolated his ideas of legitimate sovereign power to society at the international level, concluding that this scope as well ought to be ruled by just forms respectable of the rights of all. The common good of the world is of a category superior to the good of each state. This meant that relations between states ought to pass from being justified by force to being justified by law and justice. Some scholars have upset the standard account of the origins of international law, which emphasizes the seminal text De Iure Belliac Pacis by Grotius, and argued for Vitoria and, later, Suarez's importance as forerunners and, potentially, founders of the field. Others, such as Koskieniemi, have argued that none of these humanist and scholastic thinkers can be understood to have founded international law in the modern sense, instead placing its origins in the post-1870 period. Francisco Suarez, regarded as among the greatest scholastics after Aquinas, subdivided the concept of ius gentium. Working with already well-formed categories, he carefully distinguished ius intergens from ius intragens. Ius intergens was something common to the majority of countries, although, being positive law, not natural law, was not necessarily universal. On the other hand, ius intragens, or civil law, is specific to each nation. Thomas Hobbes in his treatise Leviathan, Hobbes expresses a view of natural law as a precept, or general rule, found out by reason, by which a man is forbidden to do that which is destructive of his life, or takes away the means of preserving the same, and to omit that by which he thinks it may best be preserved. Hobbes was a social contractarian and believed that the law gained people's tacit consent. He believed that society was formed from a state of nature to protect people from the state of war between mankind that exists otherwise. Life is, without an ordered society, solitary, poor, nasty, brutish and short. It is commonly commented that Hobbes' views about the core of human nature were influenced by his times. The English Civil War and the Cromwellian dictatorship had taken place, and he felt absolute authority vested in a monarch, whose subjects obeyed the law, was the basis of a civilized society. Lon Fuller, writing after World War II, Lon L. Fuller notably emphasized that the law must meet certain formal requirements. To the extent that an institutional system of social control falls short of these requirements, Fuller argues, we are less inclined to recognize it as a system of law, or to give it our respect. Thus, law has an internal morality that goes beyond the social rules by which valid laws are made. John Finnis. Sophisticated positivist and natural law theories sometimes resemble each other more than the above descriptions might suggest, and they may concede certain points to the other side. Identifying a particular theorist as a positivist or a natural law theorist sometimes involves matters of emphasis and degree, and the particular influences on the theorist's work. In particular, the older natural lawyers, such as Aquinas and John Locke, made no distinction between analytic and normative jurisprudence. But modern natural lawyers, such as John Finnis, claim to be positivists, while still arguing that law is a basically moral creature. Sharia and fiqh in Islam. Sharia refers to the body of Islamic law. The term means way, or path. It is the legal framework within which public and most private aspects of life are regulated for those living in a legal system based on Islamic principles of jurisprudence. Fiqh is the term for Islamic jurisprudence, made up of the rulings of Islamic jurists. A component of Islamic studies, fiqh expounds the methodology by which Islamic law is derived from primary and secondary sources. Mainstream Islam distinguishes fiqh, which means understanding the details and inferences drawn by scholars, from Sharia, which refers to the principles behind the fiqh. Scholars hope that fiqh and Sharia are in harmony in any given case, but this cannot be assured. Early forms of logic in Islamic philosophy were introduced in Islamic jurisprudence from the 7th century with the process of qiyas. During the Islamic Golden Age, there was a logical debate among Islamic philosophers and jurists over whether the term qiyas refers to analogical reasoning, inductive reasoning, or categorical syllogism. Some Islamic scholars argued that qiyas refers to reasoning. Ibn Hazm disagreed with this, arguing that qiyas refers rather to categorical syllogism in a real sense and to analogical reasoning in a metaphorical sense. On the other hand, al-Ghazali argued that qiyas refers to analogical reasoning in a real sense and categorical syllogism in a metaphorical sense. Other Islamic scholars at the time argued that the term qiyas refers to both analogical reasoning and categorical syllogism in a real sense.